Let's get away from markets and look at a more important law that's about to be amended. The government is looking to amend the IBC, the Bankruptcy Act, to speed up the process. Separately, according to news reports, the government is likely to issue a circular that will allow government agencies to recover tax dues from companies undergoing insolvency. Now, this news is important because while passing the Bankruptcy Code, 3 years ago, Parliament took a conscious decision to first allow financial creditors, that is banks, to recover their money from defaulting companies. In that waterfall, first the employees got 24 months of their salary, then banks got their secured credit, then unsecured creditors, and then only government dues. Now, this circular, can it be damaging for the IBC process? Also, what are the other amendments needed in the Act? We are asking two experts, Bahram Vakil, the founding partner, AZB Partners, and MS Sahoo, former chairman of the IBBI, and of course now distinguished professor at the National Law University. Gentlemen, thank you very much. In a way, you both are the creators of the IBC Act, so very important to get your views on the matter. Bahram, what's your sense? Government is wants to perhaps advance itself in the waterfall. Is that how you're reading it, and the consequences?
Yeah, so thanks a lot, Lata, and very nice to be with Mr. Sahoo. So I think there seems to be a rethink. This is something entirely in the government's prerogative. They decided, keeping with international precedent, that the government dues could be low in the waterfall, because whatever you take from, give to the government, you take from the banks. So in some ways, it's one pocket to another pocket, and you decide. It's not that the pie is going to grow larger. It is just how you share the pie. So I hope that the waterfall, as you have very correctly described it, is not upset too much, because then all you do is hurt the banks, increase the cost of credit, and that's a call the government will have to take.
You said correctly about cost of credit. Chances are that, in the first phase of the number of default cases, they were mostly PSU banks, and the government thought whether PSU banks get or I get, it doesn't matter. Now PSU banks are running healthy. So perhaps there is a change of thinking. But Mr. Sahoo, your thoughts. Is this the thinking in the government? Is that what you're also getting? And is this a good idea?
Thank you. It's a pleasure to be with Bahram also. No, I have no information what government is exactly considering. But definitely it is not possible to do through a circular or subordinate legislation.
Yeah.
This being a kind of basic structure, like we talk about basic structure on the Constitution of India, waterfall given in section 53 is something, a basic structure. If the government wishes to do it, it is competent to do it by amending the code. But nevertheless, it must be conscious of its implications. That means essentially we are creating, going by the Vidarbha judgment in the Rainbow judgment, where the Supreme Court considered Gujarat Value Added Tax Act. And in fact, yesterday we have a judgment from NCLT Chandigarh, that's versus Assistant Commissioner of Income Tax Department versus Anil Goyal. They have been guided by Rainbow. And they are essentially saying that the statute has created a security.
Okay.
So if that is the thinking of the government, they want to consider security by fiction of law, not by actual security.
Okay.
So you have to consider the consequences it will have, particularly on the availability of credit. If the creditors know that somebody can walk in by fiction of law and stand above me in the waterfall, so I would have no interest in fact to give either secured credit or unsecured credit. And even if I have given, and if it goes into resolution process while sitting in the committee of creditors, if I think that it is not going to benefit me much, then I would rather push the company into liquidation, which would be much more damaging to the economy. So in either way, if government is competent to do it, but if it does it, consequences will be serious.
Okay, and now that is very important. Bahram, would you agree that at the moment it is the banks who are going to take a defaulting company? Largely it's the banks who take. They have to have a committee of creditors. They do all the hard work because they are first in the queue. Now, if they are not first in the queue, do you think this can kind of paralyze the process?
Yeah, I fear that as well, because, these things were very well considered. It was not that these issues were missed out earlier. So I think so. I mean, I think, if the government decides, then at least there should be a very strict time limit. You cannot, delays are really plaguing the process, and maybe, a fixed quantum, so that, again, otherwise you will really damage the entire process. So let's see what happens. As Mr. Sahoo said, clearly this is something that will require amendment, and let's see what happens. I mean, it's still work in progress.
Okay, now should we understand it differently? In the Rainbow case, the court actually allowed only one statutory due. So is it, should we distinguish between taxes in general and some specific security? Bahram.
No, I don't think so. With all due respect, I have to be very careful, but those three judgments, I joke and call them VRR, Vidarbha, Resurgent, and Rainbow, they can have very nasty consequences. Okay. And with Vidarbha, we have already seen it. It might become into a S4E kind of. It's already V4. Okay. There are 2-3 precedents. Okay. So courts say this is very fact specific, but that's never how they're taken, especially with the Supreme Court. Okay. So you saw Global Tele, and there are 2-3 others. It will then become, it's a slippery slope down.
Okay, I just want to tell the viewers that there are 3 cases, the VRR that Bahram is referring to. In the Vidarbha case, under the law, if a defaulting creditor is taken by if a defaulter is taken by the operating creditor, the NCLT will have to admit. In the Vidarbha judgment, the court said the NCLT can use its discretion. So that's something, again, which can delay the entire process. Mr. Sahoo, if you can tell us, we know that the government is reviewing the IBC Act. What amendments would you like?
No, see, in the case of Rainbow, the interpretation was Section 48A of the Gujarat Value-Added Tax Act. Okay. And I thought it was not very damaging because the value-added tax was a matter of the past. Okay. We have moved to a different regime, GST. But unfortunately, as we have seen, as I gave the example of yesterday's judgment from NCLT, where they are going by the spirit of the Vidarbha judgment and saying that there is a kind of a security. So that is a concern. But having said that, we know that recently there was an order from the NCLAT in the matter of Excel engineering on 14th November. So that is making an additional and an interesting point that if the company were to be liquidated, creditors take a decision to liquidate the company, the financial creditors would get at best the liquidation value. Yes. So if anything we are getting through resolution plan above liquidation value, that belongs to all creditors. Okay. So why not let us distribute the resolution value of 2 liquidation proceeds as per the waterfall vertically. Okay. If there is excess, in fact there is excess because we are getting about 175% of the liquidation value. Yes. Why not distribute that 75% horizontally in proportion to the remaining claims? Okay. And that is the only solace for the operational creditors being voiceless, since they are not sitting on the committee on the decision-making table. For their silence, they are being made voiceless. They can have some assurance that they will have a share in the excess value over the liquidation value. Okay. I got that, sir. Got that. So the one big, just to paraphrase for those who don't care about the law so much, there is a liquidation value. If the bankruptcy process doesn't succeed, a company is liquidated. In the liquidation value, let everyone have, according to their own security, a share.
The remaining money should be given, the waterfall should be followed. That's the point that Mr. Sahoo is making. Bahram, would you want to add to that or some other amendments you want?
Yeah, I think that, as I said, all these three judgments in my submission need to be, kind of watered down so that there's no deleterious effect. And then also, I think what many have reported, that there is massive delay going in. Admission process is delayed in many ways. The decision making is delayed. And then after the decision is made, there are further delays about the distribution of the pot. So in all these three key areas, I think some amendments are required and they are being actively considered.
Okay, so we should get it before the financial year end. What's the sense? Will it be before March 31st? Because today the current session ends. This is perhaps for the next session. What's your sense, Bahram?
No, I think all of you have as much sense as me. I mean, it's, I think, very tight for the budget.
Okay.
But I'm certainly hopeful of the one thereafter.
Okay. I'm sorry we are out of time, but this is a very important issue that we have brought to light. We will have more discussions later on in off-market hours. But, the IBC amendment, the IBC gave us a very big push in ease of doing business because the law of contract got a little stronger. So we shouldn't allow that upper ranking to slip by, these kinds of judgments on the IBC. Let's hope for the best. Thank you, Mr. Sahoo and Bahram. We have to wrap up on Bazaar. Chartbusters coming up.
Powered by